Good evening, everybody. Can we hear me?
Yes.
Wonderful. All right, it is 7 p.m. We'll go ahead and get started here. Today is Thursday, April 28th, 2022, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. We'd like to begin by acknowledging that the land on which we gather, currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino Tongva and the Gabrielino Kizh peoples. Commissioner Ayers, would you lead us in the Pledge of Allegiance, please?
Sure. Hand over the heart. I pledge allegiance.
Pledge allegiance
to the flag of the United
States of America
and to the
republic
for which
it stands,
one nation,
under God, indivisible, with liberty and justice for all.
Wonderful. Thank you very much. Mr. Secretary, may we have a roll call, please?
Commissioner Ayers.
Here.
Commissioner Kirby's.
Present.
Commissioner Maggio.
Present.
Commissioner Montemayor has not joined us yet. Commissioner Topchin.
Here.
Vice Chair Copeland.
Here.
Chair Marks.
Present. We have a quorum. Thank you very much. And has everyone been able to look through the agenda for this evening? I see yeses. May we have a motion?
Motion to
I make
approve.
a motion to approve.
I'll second.
I hear lots of both, so can we have a roll call, please?
Commissioner Ayers.
Yes.
Commissioner Kirby's.
Aye.
Commissioner Maggio.
Aye.
Commissioner Topchin.
Aye.
Vice Chair Copeland.
Aye.
Chair Marks.
Motion passes. Thank you very much. Has everyone had a chance to look at the minutes from our previous meeting? I see yeses. Motion?
Motion to approve.
I'll second.
Wonderful. Can we have a roll call vote, please?
Commissioner Ayers.
Yes.
Commissioner Kirby's.
Aye.
Commissioner Maggio.
Aye.
Commissioner Topchin.
Aye.
Vice Chair Copeland.
Aye.
Chair Marks.
Aye. Motion passes. Thank you very much. Do we have any public comment for the evening?
No public comment at this time.
All right, great. Moving right along. We are up to the manager's report. Mr. Hollow.
Thank you, Chair. Good evening. Good evening, Vice Chair and members of the Commission. My name is Jonathan Holub. I am the Rent Stabilization Manager. And looking at the look-ahead calendar, there's one appeal this evening. At the next meeting, there's also one appeal. And at the May 26th meeting, there'll be one appeal. That's all we have on the calendar presently. Also, at the next meeting, the Code Compliance Division will give you a presentation. I believe that'll be Danny Rivas, the manager of that division, coming to present. And of course, in June, we have the announcement of the AGA and increase in relocation fees based on the CPI. But as you also are likely aware, currently there's a rent increase freeze in place. Nonetheless, we will be having the commission make that announcement because inevitably that freeze will end. And then in July, it's the reorganization of the commission. I wanted to report on eviction cases that we've heard about from Betsedic. It has increased again since the last time that I reported. At the last meeting, there were 8 unique cases that were came to Betsedic. Now there were 12 in the following week. So we're seeing that number go up, not surprisingly. Again, for members of the public that are having problems paying their rent or have received a notice to pay or quit, please do call the division at 323-848-6450 or email us at rsd@weho.org. We can provide you with resources, including the contact information for Betsedic, which is also on the website. And they will represent any member of the West Hollywood community who is facing eviction. So if you have received that notice, do not hesitate. Make sure you contact the division and contact Betzetic right away. There was a request at the last meeting to have a study session, possibly on June 9th. I haven't agendized or haven't put that on the calendar yet because in reviewing the bylaws, it's important that we have a set agenda for that, make sure we know what we're going to be talking about. So at the next meeting, I'm going to agendize a period for discussion among the commission to tell staff what it is you want to specifically discuss at that study session. And then when we have that, we can go ahead and calendar it and calendar based on what looks like the most light meeting, I think would be the most appropriate, or keep the meeting completely open just so we can do that. Again, as I mentioned at the last meeting, the next meeting will be back in City Council chambers. That is going ahead. So obviously that changes, we'll let you know right away, but it looks like it's going to happen. So the commission, staff, and any members of the public who want to be in chambers should be there, or I should rephrase that. You will be there, I will be there, my staff will be there. Members of the public have the choice as to whether they want to be there or not. There is a Zoom option. Hopefully all the technology works in the way it's supposed to. So if you're a member of the public watching and you want to give public comment, but you have a concern about attending in person, there will be an option, and that will be indicated on the agenda when it comes out. Or again, you can contact the division for more information about how to appear that way. But please do come if you want to. We will be open for business. And that's all I have. So if there are any questions, I'll be happy to answer them.
Commissioners, any questions? Commissioner Cooper?
Yes, I just have one question about, some of our social service providers have in the past offered rental assistance. This is pre-COVID, in times when people just had difficulties paying rent. Do you have any assessment on how those organizations are doing now? And my guess is that they are overburdened and have lots of requests, but I don't know that for certain. And are there resources out there for tenants who are behind on rent as of April 1st?
There are. I don't know if they're overburdened because those contracts are managed through our social services division, and I haven't gotten reports of them being overburdened. There are limits on the help that's available. So some people may have exhausted their what they're entitled to, but there, as far as I'm aware, there is still funding available, and even if you've applied before, I would still encourage anyone who's in need to do so. And in fact, to just contact our social services division directly. Their contact information is on our webpage, weho.org. And, they definitely are working towards helping tenants who are in need.
Thank you.
You're welcome.
Commissioners, other questions? That is all right. Wonderful. Thank you, Mr. Holub. All right. We are moving on to item number 8, commissioner comments. Comments from commissioners. I see Vice Chair Copeland, quick on the draw there.
Hi, thank you, Chair. If you indulge me for just a minute for a liaison update from the public safety.
Wonderful.
I've been attending the regular public safety meetings, and there was a special public safety meeting held last week that I attended with a consulting firm called Strategy Corp from Toronto. And they've been engaged by the city to help develop a single integrated community safety and well-being strategy for West Hollywood. So they received a lot of input from the public safety commissioners regarding current strengths, opportunities for improvement, key areas of concern, and service gaps, et cetera. So Strategy Corp said they will be engaging the public as well as other commissions. And I'm sure you'll probably hear more about that commission engagement from staff, maybe tonight or next meeting. But I'll be getting more information about that. I spoke with Chair Berger, and I'll update you when I get more information. But while the information gathering process is going on, and public safety is certainly currently a hot topic of discussion and debate, it's important for everyone to either attend those public safety meetings or send in their comments, email their public safety commissioners and their council members to share anything they've observed, experienced, or any concerns that they have with regard to public safety. I also attended the East Side Neighborhood Watch meeting last night, which was attended by the mayor and the mayor pro tem, council member Erickson, and we had speakers and representatives from the sheriff's department, including acting Captain Mulder, block by block security, the Met team, and our city's strategic initiatives manager. So members of the public and the neighborhood watch group were able to ask questions and address concerns about safety and gather some information. One of the things that acting Captain Mulder mentioned was there are a couple of legislative proposals that are ongoing right now, including the governor's care court proposal. And they spoke of some of the difficulties involved in trying to get the folks who are unhoused or perhaps having mental health issues to accept help and to get that help. And so they feel like this might make this a little bit easier if some of these go through. So I hope our neighborhood watch programs will become more active. It's a great way to engage with our local law enforcement and leaders, as well as to let our neighbors know what's going on in our own individual neighborhood. So the last thing I have with regard to that is that National Night Out will be observed the first week of August. So we should stay tuned for some announcements of events that are going to take place in different neighborhoods during that time. So thank you for indulging me, and I'll try to keep you updated when I hear more information. Yeah, thank you, Chair. That's it.
Appreciate that. Thank you for the update for everyone. Yes, Commissioner Ayers.
My comments are also public safety related. It actually is a topic where public safety, housing, and human services kind of intersect. And that is, I've read in one of our local media outlets that the city is moving forward with a plan to develop bridge housing at the Holloway Hotel property. And I'm sure this is going to take lots of time, but I think things are starting to move forward on that. And it's raised some concerns with community members around public safety, having bridge housing in a location and in what public safety concerns there might be around that, but people are already starting to express concerns. So I am just putting that out there because I'm hoping that the city is going to get in front of this to receive community input. I personally am happy that the city is moving forward in a way it can do its part in the effort to reduce homelessness in a way that provides like a wraparound housing services and human services. I'm very supportive of that. But I want the public to feel that they're being heard on their concerns and that their concerns are being addressed. And whether that falls in the purview of public safety, human services, or housing, it's all intertwined. So I'm just putting that out there for the city and the community to hear, because I think there is a need for the city to actively address concerns regarding this. Thank you.
Thank you very much. Any other commission comments? I see none. All right, we will move right along. We have an appeal now. This is D-4620. Do we have all the parties present for this, Mr. Secretary?
Yes, we have attendant James Gillum and representing the property, Sylvie Sandoval.
Wonderful, thank you. All right, we will first hear a staff report from our legal counsel, and then The appellant in this matter, which is the landlord or landlord's representative, will have a total of 5 minutes that you can split into your opening segment and a rebuttal. So when we get to that point, please let us know how you'd like to split your time. And in between those two split times, we will have time for the tenant to speak, which will be 5 minutes. And again, this is after the legal counsel gives his report. And then when both the landlord and a tenant get to their portion of this tonight, they will state their name and their city of residence for the record. And then you'll proceed with your comments. To both parties, your speaking time is limited, so please keep in mind to stay on topic. Please don't introduce new evidence, only issues that were raised at the hearing or evidence that was submitted to the hearing examiner, nothing that is new. And that's city law and city regulations. So we will start with our legal counsel giving a staff report and then turn back to the landlord and tenant.
Chair, and good evening, Vice Chair, Commissioners. My name is John Natalizio, and I am the legal counsel to the Rent Stabilization Commission for the city. This appeal was filed by the landlord, Normandy Towers, Inc., in response to a hearing examiner's decision, which in relevant part granted a rent reduction application submitted by tenant James Gillum relating to the use of an outdoor patio space and the removal of access to an outdoor faucet. The hearing examiner granted a relevant rent reduction for the following issues: $23 for the loss of the patio use and $23 for the loss of the outdoor faucet use. Therefore, the hearing examiner granted a total rent reduction relevant to this appeal to tenant in the amount of $46. The landlord filed its appeal of the decision. The appeal claims that the decision is clearly in error and it's not reasonably supported by the findings made or evidence in the hearing record. Landlord's appeal makes a number of allegations and challenges the decision, as well as including additional evidence with its submission. Staff has reviewed the appeal record and recommends affirming the hearing examiner's decision. The hearing examiner correctly determined that in this instance, a housing service shall mean services listed on the unit's re-registration form, as well as services actually provided by the landlord or agreed to by the landlord and tenant. The hearing examiner also correctly noted that if a landlord discontinues or substantially reduces a housing service without a corresponding rent reduction, the tenant is entitled to a rent decrease. Regarding the patio use, while landlord's policy may have been to not permit the patio to be used as some sort of gardening area, ultimately letting tenant maintain and water plants for years resulted in a housing service that was actually provided by the landlord. The evidence and testimony in the record shows that the tenant used the brick patio to maintain and water plants since the initiation of his tenancy. The record shows that tenant's use of the patio for his purpose was made evident to landlord from the beginning of his tenancy. The hearing examiner found that landlord acknowledged that other tenants currently have plants in similar common area locations. Therefore, staff believes that there is substantial evidence in the record to support the decision. Staff also believes that the rationale and valuation of $23 was reasonable and is supported by substantial evidence in the record. Regarding the outdoor faucet, the hearing examiner found that tenant had used the outdoor faucet since the beginning of his tenancy to water his plants. The record suggests that other tenants are also using similarly situated faucets throughout the property and that this was not unique to tenant. There does not appear to be anything in the record to suggest that tenant was ever informed that use of the faucet was improper. The record also appears to suggest that tenant was never informed that his access to the faucet would be eliminated. Additionally, tenant's testimony during the hearing is that other tenants have continued to use faucets that are located near proximity to their units. Landlord's justification for eliminating the faucet is in part that it was leaking and ultimately too corroded to fix. And while this may be a legitimate explanation for why the faucet needed to be replaced and or removed, it does not rectify the fact that a housing service was eliminated. Further, while landlord may have increased water costs in water, their water bills after tenant moved into the unit, this ultimately is not tenant's problem. Therefore, staff believes that substantial evidence in the record supports the decision, and staff also believes that the rationale and valuation of $23 was reasonable and supported by substantial evidence in the record. Therefore, based upon the above, staff recommends adopting Resolution RSC 22-612. You as the commission have the power to affirm, reverse, modify, or remand the appeal decision of the hearing examiner. The commission reviews the hearing examiner's decision under the substantial evidence standard, which requires the commission to make sure there is substantial evidence that reasonably supports the hearing examiner's decision, is credible and of solid value. If that evidence is found, then the decision must be upheld, even if there's also evidence that could support a different outcome. The commission does not substitute its judgment for that of the hearing examiner or reweigh the evidence. And as it relates to questions of law, the commission applies an independent or de novo standard of review to the hearing examiner's conclusions of law. Thank you.
Thank you very much, Mr. Natalizio. Questions, Commissioner Kerpes?
Yeah, I just have a question about the access route to this patio is through a bay window, from what I understand from the evidence. And I know that in itself is not relevant to the decision in front of us this evening or the appeal in front of us this evening. But should the commission want to follow the staff's recommendation and affirm the resolution and affirm the hearing examiner's decision, do we have the authority to determine that the use of the bay window and cutting that off in the future, should the landlord want to put up a screen or something like that, could we clarify that would not cause an additional lack of a service, or would that go beyond our authority?
I guess I can respond this way. I think for purposes of this appeal, it probably exceeds the commission's authority. There could be some situation in the future where maybe that is something, but generally, ultimately, where commission's kind of ordering some sort of specific performance on the part of a party, that would generally be outside the commission's powers. So I'll say in this situation, for this appeal, it would be outside the commission's scope.
Thank you.
Commissioners, other questions from Mr. Natalizio? Okay, I do not see any. Thank you for your report. Much appreciated. All right, we have Mr. Gillum, I see, is present, and then Ms. Sandoval is present. Ms. Sandoval, you can turn on yours. Thank you. You're the representative for the landlord here?
Yes, I'm present.
Okay, wonderful. Thank you for being here tonight. We're going to start with you since you are the appellant here. Again, please state your name and your city of residence before you start, and then you will have a total of 5 minutes. Please let us know how you'd like to divide your 5 minutes.
Well, I think that my response is fairly simple. I would like to do perhaps 2.5 minutes in the beginning and 2.5 minutes at the end.
Okay, wonderful. So state your name, city of record, and then once you do that, your 2.5 minutes will start.
Okay, my name is Sylvia Sandoval, and I reside at 7219 West Hampton Avenue, city is West Hollywood, California, 946.
Okay.
So California has the implied warranty of habitability, requires the landlord to keep the premises in condition fit for the occupation of human beings. Therefore, the premises have to be a place for them to live, and the rooms have to be used for the intended purposes. They cannot destroy or deface the premises or allow anyone else to do so. So the landlord has an obligation to maintain safe premises, and it's a fairly well established that bricks are unstable. And the use of a brick instead of a step is a hazard. So the loss of a patio use that never existed should have never reached the examiner hearing. And also the plans are still in place. The tenant filed a false hearing because he never removed the plants or his personal property from this area. When we received notification of the hearing, we never received any evidence. I spoke with Eric, and I also spoke with Gloria at the rent stabilization, And I told them, why is he allowed to file a hearing without removing the plants in his personal property? They told me to bring that up at the hearing, which I did, but it seemed like the examiner completely overlooked the fact that the plants are still there. To this day, he still has the plants. We would gladly give him the $23 rent reduction if he removes the plants, but he cannot have both. He cannot keep plants in the so-called patio and have a rent reduction. That's not possible. That is so beyond unfair to the landlord. So that is not going to happen. He needs to remove the plants and he will get the $23 rent reduction. Please let me know when the 2.5 minutes are up.
Mr. Secretary, how much time left on the 2.5 minutes?
2 minutes and 45 seconds left out of the 5
Yeah,
minutes.
so it's very simple. He can reply, but the fact is that the plants are there. And if he wants a rent reduction, he really needs to remove the plants and the landlord would be gladly give him the $20 rent reduction.
Okay, wonderful. Thank you.
Okay, sure.
We are going to now turn to Mr. Gillum. You'll have 5 minutes max. You obviously don't have to use all of it if you do not want. Please state your name and your city of residence for the record. And then once you do that, your 5 minutes will start. Ms. Sandoval, if you can turn your microphone on to mute, and then Mr. Gillum, turn yours on.
Hello, everybody. Thank you very much for the time. My name is James Gillum. I am a 7-year resident of West Hollywood, California. My statement is pretty brief. I disagree with the appellant's claim that the determination is clearly in error. I filed for this rent reduction originally in August of 2021. There were no illegal modifications to apartment 12's patio space. Tenants before us have long made use of this patio space, and I suspect that tenants after us will as well. It had been inhabited by our furniture since before current management took charge, and we utilized it for years as a space to catch fresh air, toil happily with a modest collection of potted plants, and hang out with our beloved indoor-outdoor cat, Ella. Furniture, both private and that of management, has accumulated among and beside certain apartments, as have other potted plants belonging to both management and other renters. We oblige management's request to remove the majority of my plants and our furniture entirely from the patio, and have documented that pretty thoroughly in the previous findings. I have lost use of the patio space, over $600 of plants, pots, and furnishings since 2019. The water spigot I once used once or twice a week to water my plants has been closed off and remains welded shut. These changes constitute significant losses for use of well-established housing services that, as determined in the hearing, many others around the complex still continue to enjoy. The joy I got from gardening and tending to plants was priceless, but I do appreciate the hearing examiner's decision to adjust our rent to some proportion of our loss. I am very much looking forward to setting a boundary here that protects the interests and investments of both parties. I find that the hearing examiner's findings are fair, even in the case of issue 4, which was dismissed, but succeeded to inspire current management to conduct certain repairs that have been ignored for multiple years and through multiple changes in management. I am extremely grateful for this and this process and all of your time. Our patio space was significantly cut back, our faucet removed, the lease was unregistered, and our rent has been illegally raised. Our privacy has been compromised. All of this is the consequence of mismanagement or harassment. Unfortunately, this mismanagement and harassment has created a significant decrease in the value of living here, for which we appreciate the chance to adjust the rent we pay to a place we call home. Thank you.
Thank you, Mr. Gillum. All right, we will go back to Ms. Sandoval. Mr. Gillum, if you can turn your speaker off, and Ms. Sandoval, you can unmute yourself. Mr. Secretary, how much time is remaining for Ms. Sandoval?
2 minutes and 32 seconds.
All right, Ms. Sandoval, you have 2 minutes and 32 seconds for rebuttal.
Yes, no one else in the property is using the common area in front of the building, and no one else is misusing a window as a door, so that it's pretty much illegal to do that in California. He is the only one who is using the front of the building as his own private patio, and he must remove all the plants from the private area of the property in order for him to get a rent reduction. It's fairly simple. I really have nothing else to say. No other tenants are using this area. He is the only one, and everybody else obeys the law. This is a historic building. No one is allowed to use a common area of a historic building as his own private patio by basically breaking into it through a window. So that's so unfair for so many reasons, and it's illegal.
Okay, wonderful. Thank you for your comments. Commissioners, do we have any questions for Ms. Sandoval or Mr. Gillum? Commissioner Topshin and then Commissioner Kerpes.
Thank you, Chair. A question to Ms. Sandoval. You mentioned no one is using the patio area. Obviously, I don't see the door from the tenant's unit leading to that patio area, but who has access to it? Because it still somehow has to be maintained or something. Who has access to that area?
Basically, it's an area where the main water is situated. Our gas meters are in that area, the irrigation system. So it's been really, it should not be accessed by anyone except for like our service technicians or the fire department. And this is what started the whole situation. The fire department requested that we keep that area clear.
Okay, so now, you answered the question. So now the next question is there a gate leading to that area? Is it locked? Can the tenants, just the way that, let's say, the fire department personnel or management personnel can enter, can the tenants use the same entrance and get into the area? Is it accessible, physically, actually accessible to the tenants?
It would be, and I think at one point it would have been fairly accessible, but some trees have really grown in over 100 years. So they've overgrown and they kind of block the access to that area. So I think that when the building was first built, there was a very good access through the side.
But still, still someone can go in.
Yes,
nothing prevents to access. So is there a lock on the gate? Is there a lock on the gate, or the gate
No,
can be
there's
open?
no lock, but it is the intention of the landlord once the tenant remove his plants to put a gate and lock that area to prevent from intruders into that area. But at this time, we never had any reason to put a lock in this area because we want to leave the property open in case of an emergency, like the fire department has requested, and also code enforcement told us that that area had to remain clear. Fire department requires 18 feet of
I understood
access.
that.
Yes.
Thank you.
So
the last question for now, if the tenant choose to, enter from that gate that is not locked, he would be able to enter, right? Rather than using his bay window. So nothing would prevent the tenant to get out of his apartment, go around the building, and go into that area through the gate that is unlocked.
Correct. That would be what we would hope to, because as it is, it's very difficult to get insurance for the building because of the age of the building. So we don't want any more liability for somebody jumping through a window. Exactly.
Yeah, I appreciate your responses. Thank you. Thank you so much.
Thank you.
Thank you, Chair.
Very welcome. Commissioner Kerpes.
Yes, thank you. I have the same question both for Mr. Gillum and the landlord, Ms. Sandoval. So Mr. Gillum, how many plants do you have out there currently? Or have you removed them all?
I've removed all of the plants. There are 2 wire racks that have been there longer than anything, and it's most exemplary of the sort of thing that everyone else has hanging around. So those are the 2 remainders.
You have 2 plants remaining out there?
No. I have 2 little wire racks. They're about, I'm going to say, 2 feet in width, and there's tiny little pots throughout them.
Oh, okay. So
It's off the ground so that no leaves catch below it.
and are you intending to remove those?
I honestly was waiting to understand more about this process and how it goes with that. If it has to be removed, ultimately it's not my property, and they're fully within their right to demand that we do remove them. I thought it might be a nice option to, pad back and take that extra 23 if they wanted to let us leave it there.
Thank you. And Ms. Sandoval, same question for you. How many plants does Mr. Gilliam have out there?
He probably has about 20 plants. He likes to grow plants, and he just keeps adding more. And the rack
I'm
he
just
has
wondering
that
how many he has out there right now.
about 20. And the rack that he's mentioning, I threw it away in the trash when I moved in July 2019, and he got it out of the trash. And
That's all right.
No, I'm just telling you because it's since 2019. It hasn't been there forever. So I know exactly
My
what
question
he's
is
using.
just about this evening, but I think
Okay, thank you.
answered. Thank you.
Thank you.
Chair.
You're welcome, Mr. Kerpes. Fellow commissioners, questions? I do not see any. Okay. Mr. Gillum, Ms. Sandoval, thank you for your testimony to us tonight. We are going to deliberate and reach a decision. Commissioners, who would like to begin? I see Commissioner Topshin.
Thank you, Chair. When I first read the appeal, I had a little bit of more concerns, but after asking these questions to the landlord, now I have a complete picture. Regarding the patio usage and access, so although it's clear that there is nothing in writing that shows that the patio was provided as a housing service, and there was a testimony made, but in the testimonies, the landlord and tenant, they both confirmed there was no verbal agreement between them to use the patio as an exclusive use. And clearly, since the tenant's unit doesn't have direct connection with the patio through the door from the tenant's unit leading to that area, so I wouldn't say that the tenant has an exclusive use of that area, of patio area, because otherwise there wouldn't be a door leading to the tenant, leading from the tenant's unit to the patio. That would have established the exclusive use. So there is no exclusive use, and I have a trouble of kind of a, but it could be a different issue though, a safety or some other issues. But I have a trouble of accepting, understanding the use of that a bay window to access. I think it's dangerous. I don't think it's safe, but that's not what I'm looking into. But the fact that this area is accessible, anyone basically can open the gate and go in that area. That makes that area a common area, accessible to everyone, every tenant in the building. Initially, I had the trouble of accepting the examiner's decision on this patio matter because, as I said, because of the agreement didn't establish anything, that didn't establish exclusive use. There was no verbal agreement between tenant and landlord. But since it's a common area, if it's a common area, it doesn't have to be anything in writing or anything specifically saying that this area is available to the tenant, unless there is an exemption to use that area. If the rental agreement would have said the tenant prevented to use the patio area, then we're going to say there is no housing service. But the fact that the rental agreement is silent on this matter, and the tenant has physical access, that establishes a common area, just like a pool or a gym or a barbecue grill. All the services, they don't have to be listed in the rental agreement to be considered as a housing service. When the tenant rents the unit, and if there is a common area that tenant has access, unless the tenant is told you don't have that access, then that is a common area housing service available to the tenant. And if the service is later removed, that should be a corresponding rent reduction. So that establishes, at least in my opinion, that this area is a housing service. So the second question would be about removing the plants. Although the tenant has access to this area, the question about the plants is if the tenant for years had those plants and that never been an issue, so then by asking to remove these plants, that would constitute a reduction in housing services, and the corresponding rent reduction should apply. So in this matter, if the tenant removes the plants, then if the examiner determined $23 of rent reduction shall apply, so then so be it. But as I agree with the landlord's representative, the tenant cannot have both. So if the tenant is taking the $23 rent reduction, then has to remove the plants. So that is clear to me. So that's on this patio that I would support the findings of the examiner. However, I have a problem with the outdoor faucet. If you review the rental agreement, the second page of the rental agreement, which is the page 26 of our packet, the under section utilities, the second from the last sentence says, renter shall not use any common area utilities. So, which means that the tenant cannot use the water, outside water, which is the utility. So I would say that the decision, I wouldn't agree with the decision to grant the rent reduction for the for not allowing to use the water faucet, because first, there are a couple of things here, the way I think. The first, obviously, the rental agreement clearly says that the tenant shall not use common area utility, and the water service is a common area. And the outdoor faucet is a common area utility that provides water supply. That's based on the rental agreement, which is I think the most important argument that I have. The second argument is I have not seen the cases where we would say the outdoor faucet is a housing service. By its definition, it's not something that is meant for the tenant's use. It is a use for the landlord to maintain the common area. So it is not the tenant's use. And just because a tenant had access and used it, I would disagree with the decision that just because the landlord did not ask to remove it or stop using it, that will become a housing service, because by itself, the outdoor faucet should not be considered as a service connected to the tenant's use, unless there is a specific clause in the rental agreement or there's a specific verbal agreement confirmed by both tenants and landlord that it was part of the agreement made between tenant and landlord, then we should stay out of that. So that's my position. So I agree on the patio, but I disagree on the outdoor faucet matter here.
Great.
Thank you, Chair.
Thank you very much. Commissioner Maggio. Yes, sir.
Almost in total agreement with Commissioner Topshin. To support part of his argument, which we would probably have to refer to our West Hollywood Municipal Code 17.08.010, specifically 10, which does talk about housing services. And if we read most carefully, it mentions many items, but it does not mention plants. It does not mention faucets. The closest it would come to it would be any other benefits and privileges or facilities or the terms of condition of the tenancy. Of course, none of that was ever in writing. And I think we have to support that ordinance. In my opinion, this was always a front common area that was never meant to be adopted for any personal use. Thank you.
Thank you very much, fellow commissioners. Commissioner Kerpes.
So I agree with portions of what my fellow commissioners have mentioned previously, but think about it differently also in some aspects. In regards to the water faucet, I'll start there because it's easy for me. The water faucet issue, although the lease says there's no access to it, and the hearing examiner, their job is to review the facts of the case and whether it was allowed to be used or wasn't allowed to be used, or was it used or was it not used, was the usage stopped? Clearly, in this case, there's no doubt that the usage is stopped because it no longer exists. And I think the hearing examiner's role in the hearing is to determine whether the service had existed and was taken away. And I understand where my fellow commissioners are on that issue, but I do think that we shouldn't override the hearing examiner in that area, because that's his role to determine the facts and whether that was a service that was taken away or not. So I would be inclined to support the hearing examiner in that aspect, that was a housing service taken away. I am conflicted on the first portion regarding the access to the patio. So I agree with Commissioner Topshian that the access necessarily wasn't, the access and use was only partially removed, because the tenants does still have access to it. They can still walk around the building just like other tenants can. However, the hearing examiner did determine that I think there's patio furniture involved that was property of the tenant that wasn't allowed to be there any longer. There were personal plants we've talked about tonight, something that a planter. So if those things were required to be removed, I would again affirm the hearing examiner's decision that was a service, because the ability to put out furniture is a little bit different than the ability just to go and hang out in that area. I think the tenant does still have the ability to go and hang out in that area, just like any other tenant in the building. But clearly, the direction from the landlord is to not put your own personal property out there. Don't put your plants out there. And so that has been removed, and or at least theoretically that service has been removed. However, tonight, both witnesses are saying that not all the items have been removed. So there has not been a complete loss of service in my mind. It's not for us or the tenant to decide which option to choose. It's the landlord's determination of whether they want to allow a certain service or remove a certain service. And I do kind of feel like that this hearing was premature on that aspect, because the tenant should have to show that there was a loss of the service first. And maybe there is a diminished loss of service, but I don't feel that there's a complete loss of service yet because of that aspect. But I'd love to hear what my fellow commissioners think. And if you can recall any cases in the past where, I know we often hear cases where the issue itself has been resolved by the time it comes to the appeal, because the tenant and the landlord have worked some sort of agreement out. But in this case, to me, it sounds like there was never a full loss of the service of, say, having the planter, having the plants out there. So that's where I'm at right now, and I'd like to hear what others have to say. Thank you.
Great. Thank you very much. Commissioner Ayers.
I agree with Commissioner Kerpes that this may be a premature decision, because we have a situation where the services of the plants has not completely been removed. If there are still plants there, then, you know, it's hard to make a decision based on that. the plants either need to be removed or they stay, and then a decision can be made, I guess. But I agree that, that there is a established service that the landlord had let ride, whether officially in the landlord's mind that these were not common areas to be used by the tenants. What the tenants did showed otherwise, and this tenant wasn't the only tenant using public space in that manner. So if it is taken away, then I agree that that there should be, recompense. There should be lowered service. And in the case of the water spigot, that's already happened. The rent should be lowered accordingly. But right now, he hasn't completely lost the service of a place to put his plants. So that still, I think, is an open situation.
Great. Thank you very much. Fellow commissioners, Commissioner Montemayor, Vice Chair Copeland, Mr. Montemayor.
I'll start with the faucet spigot. I agree with I think all my colleagues, but Commissioner Kirby's and Commissioner Ayers. That's an easy one for me. The service has been lost. It's been removed. And I think it was an established service. As for the loss of service of the patio for the plants, I'm having trouble reconciling how I feel. I think I was leaning towards Commissioner Topshin's argument, but Commissioner Kirby's has intrigued me, and I suppose I understand why this would be premature. And I do think the onus is on the property owner to establish and to decide that use and to remove the service. That service has not been removed by either the tenant or the property owner. So now I'm talking myself into Commissioner Kirby's line of thought. I agree with Commissioner Kirby's and Ayers.
Great, thank you. Vice Chair Copeland?
I was reminded of a case that we had not long ago when we were talking about certain areas not meant for access, perhaps, or for the use that they were being used for, but being allowed to continue for some time. We had a case with rooftop access not long ago, and that wasn't what it was intended for. However, for several years, some of the tenants had put furniture up there, plants up there, went up there to hang out, and that was removed. And there was only one way to access that, and that rooftop. And it wasn't an easy, or common access, but still, it was a service that was allowed and that was removed. So I think, especially as a quality of life issue, to remove, if you enjoy gardening and plants and you've been doing this for some time, and you take your cat out there, you have, and all of a sudden it's okay, you can't do that anymore. And I think the fact that it sounds like that maybe 90% of all of that has been removed. So it's not, it's definitely a loss, but it's not 100%. My thought on that is that certainly the landlord could get a compliance determination but they would have to restore full access, or the tenant would have to completely remove, it has to be 100% one way or the other, I think. So I agree with my fellow commissioners on that part. The water spigot, I think that was something that was obviously used and has been removed, as my fellow commissioners say. So I have no issue with that. I would be in favor of, staff's assessment that the hearing examiner's decision should be affirmed. But I think that definitely the landlord could get a compliance determination if they say, well, it's not been taken away, it's being used. But I would hate for the tenant also to have 10% of what they had before, and that would be considered full use of the area. So I think I agree that there should be some 100% one way or the other here for the reduction. But those are my thoughts right now.
Great. Commissioner Maggio, let me say my comments here and then we'll go right back to you. I agree with Vice Chair Copeland. I think when we're kind of going through these, we have strayed from the legal standard of review that if a reasonable fact finder could have come to the same conclusion on the facts in the record, that we would uphold it even if there's contrary evidence in the record. And I think that here the hearing examiner had the facts in the record to make that decision, and that's what a reasonable fact finder would have done. I also don't know if the statements tonight are new evidence for us to consider, whether there's plants out there or not. I fully agree that even though a lease says don't do X, Y, and Z, if over a certain amount of time a tenant uses a water spigot, even if the lease says whatever, then it becomes a housing service, and that's pretty standard and under state law and case law beyond, and I think it's applicable here. But I also agree with Vice Chair Copeland that a compliance determination is the best way to determine that, not us, saying is there partial usage or half usage, or we're not there. And I think the staff's recommendation is correct. So those are my points. Commissioner Maggio, did you have updated comments?
Yes, my update is I still believe that there's no reason for the faucet if you don't have the plants. They go hand in hand. But I would again reiterate that this common area was adopted by an individual and made it their own. So I can't be in agreement with any loss. I feel that it is the right of the owner to put back in place what they consider to be legal under safety and, of course, insurance issues. Thank you.
Thank you. Commissioner Kerpes and then Commissioner Topshin.
I just had a couple of questions, I guess, about maybe Vice Chair Copeland and Chair Martz, your comments about compliance. So my understanding, and maybe Mr. Natalizio could clarify for us, but my understanding is the compliance determination is made when an issue is ordered, clear the patio. The patio has been cleared, and now the landlord wants to say, no, I'm giving him access to it. He's going to put his plants back. And the landlord then comes back and says, okay, I'm allowing this. Now I can increase the rent again. That would be fine, except in our case, I don't believe that there was ever a removal of the service completely. The plants never were removed. So I don't think it's right that the tenant should be awarded a full $23 for the removal of only a partial service. I'm not saying that 100% he's maintained the service, but under what was ordered, I don't feel like we're in the position to decide that. The landlord either needs to, who has the authority to remove those items, needs to enforce that or not. And if they choose to enforce that, then there's the loss of the service.
Commissioner Maggio?
Yes, but Commissioner Kerpes, we are allowed to modify the amount if we choose.
Commissioner Topshin?
Just to emphasize on the outdoor outdoor faucet issue. So I see the direction the commission is heading regarding the patio, and I would agree with most of the remarks or comments made by Commissioner Kerpes, and I will be fine with the patio. The discussion the way that you will be suggesting, or you're suggesting. But I want to emphasize, I believe the examiner erred in determining that the outdoor faucet is a housing service. It is not, because the rental agreement That's why there was a rental agreement. The rental agreement clearly states it is not within the tenant's use. So it cannot be considered a housing service under the definitions of the ordinance, which is 17.08.010. And it says the housing services for tenancies commencing on or after January 1st, 1999 shall mean services listed on the unit registration form filed with and accepted by the city, and any other services actually provided by the landlord or agreed to by the landlord and tenant. So here, the rental agreement clearly demonstrates this was not a service that they agreed on when they rented the unit. So just because it's there and the tenant decides to, to take upon himself to just use it, it doesn't become a housing service. When the rental agreement clearly says the tenant doesn't have that use. If the rental agreement wouldn't have that clause, I would say, okay, just like in a patio, in the patio part, the rental agreement is silent. There is no description what to do with a patio. The tenant used it. The landlord didn't do anything about it. So that became a housing service. But for the outdoor faucet, it's different. It's stipulated in the rental agreement. So that was a term that the tenant agreed upon to when the unit was rented. So I disagree with that part, but I see the commission's position. I disagree with you, commissioners. But if you still believe that that's a housing service, which I think the examiner erred in that determination. So if you believe that you're going to affirm that, then I will not support that tonight's findings. Thank you. That concludes my comments.
Yes, Vice Chair Copeland. Oh,
I just wanted to, I guess Mr. Natalicio can chime in here if he needs to. My concern with whether there are or not plants at this time on the patio is, to me, that's new evidence, what's going on today. The hearing examiner saw the evidence of what happened or had happened before the hearing and made his determination based on that evidence. So to me, trying to get sort of an update on what's there today, isn't that the same as new evidence, Mr. Natalicio? So that's why I suggested a compliance determination to see what's going on today, as opposed to us trying to make a decision based on one party says there's this 20 and one says there's a, we're seeing the evidence that was in the record according to the hearing examiner's decision, not what's going on today. Is that correct?
Yes, Vice Chair Copeland, that's accurate. Just like I think the commission has seen before, where and I think Commissioner Kirby's brought this up, where the landlord says, oh, well, we fixed all of this after the hearing. It's the same kind of premise here. We're locked in time at the date of the hearing. And so it's whatever was before the hearing examiner. So I will say, as to what's happening right now, that would probably be new evidence. But the thing I wanted to point out was the hearing examiner, and so let me just pull up the decision here, notes actually in his decision that not all of the plants were removed at the time of the decision. So that was factored into his decision. It appears to me that his understanding of the order by the landlord was complied with by the tenant, which is why he ordered the corresponding rent reduction. And there was a conclusion, I believe, sorry, 1 second. It's conclusion of law fact number 6. It's on page 46 of the PDF packet. It's 11 of the actual decision. And it says, but in 2011, the landlord required Mr. Gillum to remove most of his plants, which he did. And then in conclusion of law number 2, which is on page 47 of the packet, he says, Mr. Gillum has suffered a reduction in housing services with respect to the ability to both lodge and water his plants. And so my understanding of that would be is the hearing examiner was aware that there were some plants remaining on the property, that the landlord's orders were to remove most of the plants, and that the tenant did, and that there was a substantial reduction in the housing service as a result of that. So I know that there's both substantial reduction in housing service and as well as a discontinuance or elimination. So I don't know if it has to be 100% eliminated in order to result.
That was my understanding. So I just wanted to be sure that that I was looking at that the right way, because maybe it was plants that were obstructing a pathway, or you can see in the photos there were still some when he made his determination. So whether there's more today than there was then or less, to me, wasn't really something we needed to examine tonight. So that's why I had said I was in favor of affirming. So that's all I have. Thank you.
Great. And based on Mr. Natalizio's comments, I would agree with Vice Chair Copeland here. I think Commissioner Kirby's had a hand up.
So the fact that, I think that we just kind of heard a full circle, and I don't think you intended to do it, Mr. Natalizio, but you said that tonight was new evidence about the plants being there, but yet the record shows that there were plants still remaining there. So that's not new evidence. The landlord also had brought that up to both the city staff and to the hearing examiner during the hearing, that this was a premature hearing. They argued. It does sound like the hearing examiner did take that into consideration. So I'm not really sure where I'm at right now. On the other subject of Mr. Commissioner Topshian's argument, I think I do understand, Commissioner Topshian, what you're saying. You're stating that unlike a situation where you're given one parking spot with your lease, but you end up using 2 parking spots, and that's allowed over time, and we have granted that, you're saying in this case, the lease specifically said you are agreeing to not use that common water faucet, and so since the tenant agreed to do that, they're bound by that for in the future. Is
correct,
that
because the rental agreement specifically excludes that as a housing service. If it wasn't there, we would argue the same way as we're arguing with patio or in other services, but that specifically excludes. Just like I brought up the example, let's say the common area pool. It's not necessarily that a rental agreement would stipulate the tenant has a pool. Let's say it's a 1-page rental agreement, not very detailed, and there is a pool, outdoor pool, but it's not identified, it's not listed in the rental agreement. We would say, because it's in a common area, the tenant has access to the pool unless it's excluded specifically in the rental agreement, saying that your rent that you pay does not include pool. So in that case, it's not a housing service, and the tenant cannot use the pool. So the same thing is here. And in addition to that, if we consider by its definition, the outdoor faucet is not meant to be used for the tenant's unit, for the tenants, it's not attached to the tenant's use. It is for the use of the common area services, that is for maintenance or any other use, because the landlord pays for the water usage, not the tenant. So the tenant cannot use it on a regular basis and say, oh, okay, so it's a housing service provided to me by the landlord. So that's another argument. By its definition, outdoor faucet cannot be considered a housing service attached to the tenant's use immediately.
Even though the ordinance says listed in the lease and any other services provided, you're saying that because they agreed that was not a service, it doesn't fall under that other services as provided?
Well, it was the hypothetical that I gave, but in this particular case, we have the rental agreement specifically excludes that from being a housing service attached to the tenant's unit, period. And therefore, the definition of housing service wouldn't apply, in my opinion. Versus the other scenario I gave, assuming that is not stipulated in the rental agreement. And in that case, whether it's a housing service or not, it would be determined by the, as you said, by the definition of the housing service, whether it's provided or not, if there is evidence or the tenant used and the landlord didn't do anything about it. So, but here it's very simple. We don't really have to go into any other discussion because the rental agreement specifically excludes it from the tenant's use. The tenant's not supposed to use it. And an additional argument I'm making is that the faucet, outdoor faucet, is not meant to be used by the tenant anyways. So that's my position.
Let's move this on. I think we're kind of beating a dead horse here. I want to kind of move this towards a at least a vote, even if it fails. So I would just say, though, in the legal world, what the lease says is not the end of the world. Leases can be modified by the behavior of the parties. And so just saying it's in the lease and it says you can't do that isn't the end of the discussion. You can, if we had a situation where it said you can't use X and the landlord came to them and let them use it, you're arguing that the lease says the lease is there. It would still be a housing service if the landlord came and provided to them, despite what the lease says. So actions are also considered in the legal world, not just what's written in the paper. So I know we have a few different viewpoints out there. We've got two issues here. We've got the faucet, and then we've got the gardening area. So where are people leaning on the faucet? Do we want to affirm or overrule the hearing examiner? Commissioner Maggio.
I'm going to overrule the hearing examiner in regard to the faucet. I don't believe it ever was meant to be a housing service.
Okay, understood. I think Commissioner Topshin's of the same position. I believe it is a housing service and would affirm.
Affirm.
Okay, okay. Vice Chair Copeland? Affirm.
Yeah, I believe it's like, my neighbor has a lease that says you can't have any pets, and the manager came along 7 years later and said you can have a cat. Then a new manager bought the building. I mean, can they come along and say, well, it says in your lease you can't have a cat, you have to get out? I mean, I would affirm it. I think it was a housing service that was allowed, even if it was not originally intended, or it was specified, don't do this, but then later they said they allowed you to do this. To me, that's sort of accepting a change in the rules, so to speak. So I would be in favor of affirming, I believe. Thank you.
And Commissioner Kirpius, do you have?
I'm still uncertain, so I'll be voting no, which I know defaults to the landlord still moving forward with getting the decrease, or the tenant still getting the decrease.
Okay. So I think in that case, the majority here has voted to affirm on that issue, the hearing examiner's decision. As to the outdoor patio gardening space, where are people leaning? My gut feeling is that everyone in some way, or most people, seem to agree with the hearing examiner here. It's whether it's the full amount or a partial amount. Is that kind of where we're at? Commissioner Maggio.
I'm looking for more of a modification on the amount because I'm not in full agreement, but I think that could be a good compromise. I believe it's $23, is that correct?
That's right.
And I would say I would modify it to $14.
Okay. I personally would leave it as is at the $23, but if there is leaning towards a modification, I don't think 14 is the right space. It sounds like most of his use has been taken away. I think it's basically full use given the landlord's conduct. So I would say if we modify it, would be 17 or 20 in my view, but I think it should be the full amount. Other commissioners?
I would agree to leave it as 23 After the legal counsel's explanation, I find that very helpful. Thank you.
Thank you for that. Commissioner Ayers.
Yeah, upon rereading the evidence and seeing that, the hearing examiner did acknowledge that there were still some plants remaining, that the tenant was ordered to remove, to clear the way and remove most of the plants, and he did comply. I would be fine with affirming the full amount.
Thank you for that. Other commissioners? Vice Chair Copeland, I think you're agreeing to, okay. Commissioner Kirpies has a hand up.
So does this set us up for, or set the landlord up for, does the tenant get to keep what he's got there now, or not what he's got there now, but what he had there the day of the hearing? And if the landlord removes that, does he get to apply for another rent reduction hearing and come back for another value? Because I would be against, actually, I don't know where I'd be on that. I think that would be a more proper hearing.
I mean, to me, that's outside the scope. If he wants to, that's his purview to do so. I think your initial question to Mr. Natalizio on a different topic kind of applies here, that's not, we're just looking at the evidence in the record. And, I don't know if the loss of 3 plants, would be worth filing, maybe so, but I think, our scope here is limited to what we have in the record here. So, but that's a legal question from Mr. Natalizio. I think if he wants to opine.
Chair Martz, I agree with your assessment on that, I think Commissioner Kirpies poses a good question, but I think that it's, again, not within the confines of this specific appeal hearing, and this might just be a future issue that has to be dealt with.
And Commissioner Kirpies, I agree. It's a good question. And I hope that despite the contentious relations between the two parties, that it wouldn't become a second hearing and process, but that's neither here nor there for this moment. Commissioner Montemayor, do you have a position on this?
Yeah, I agree with you, Chair Marks.
Okay. So I think on both of these, there's a majority opinion that to affirm the hearing examiner and support the staff's recommendation. So if someone wants to make a motion. Commissioner Ayers.
I move that we adopt resolution RSC 22-612, a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming the hearing examiner's decision as to application number D-4620.
Do I hear a second?
Second.
Thank you for that. We have a motion, a second. Mr. Secretary, a roll call vote, please.
Commissioner Ayers,
Aye.
Commissioner Kirpies,
No.
Commissioner Maggio,
No.
Commissioner Montemayor,
Yes.
Commissioner Topson,
No.
Vice Chair Copeland,
Yes.
Chair Marks.
Yes. The motion passes. Thank you, everybody, for that. Tenant and landlord, Mr. Gillum and Ms. Sandoval. If you do have questions, Rent Stabilization Division is available at 323-848-6450 or by email at rsd as in dog at weho.org. You're welcome to watch. Thank you both for participating tonight. We do appreciate it. Thank you.
Thank you.
All right.
Mr. Chair, maybe we have a 4-minute recess.
You sure can. We'll come back at 8:22. right, I see cameras popping on. Another minute or so. All right, we are back in session. Just finished item number 9. We are now on item number 10, new business. Mr. Hollop, do we have any new business?
No new business.
Okie easy enough. Items from staff, number 11.
Yes, one item from staff. So there's a focus group being convened, and the city managers asked that each commission select a member to participate in it. Actually, Vice Chair Copeland had touched on this earlier during her comments. So I'll just tell you what the project is, and then the commission can decide who they want to have be their representative. So the city manager has recently engaged a consultant to develop a comprehensive community safety and well-being study. The city has contracted with Strategy Corp, a professional services firm based in Ontario, Canada, to guide the city through the strategic planning process. Strategy Corp's team is experienced in working with local and regional governments, police organizations, and the nonprofit sector to develop and implement community safety efforts. The project will include the creation of strategic goals, prioritization of new and existing community safety and well-being initiatives, and the implementation plan for moving forward. The goal is to develop a single integrated strategy to help streamline efforts and optimize the community safety and social service ecosystem. Strategy Corp will be conducting 60-minute focus groups with representatives from all commissions and advisory boards and the Social Justice Task Force. So we're being asked to have you choose one representative to participate in a focus group to provide perspectives on service gaps, risks and barriers, and opportunities for improvement in the city's community safety and well-being landscape.
Commissioner Maggio?
Jonathan, will these meetings be in person? And if so, where will they be held? Or if not, please, more detail.
Sure. Let me just see if they gave us the information. There'll be virtual sessions, it looks like. Yeah, and the focus groups are being held on May 11th, 9 to 10, 10:30 to 11:30, noon to 1, and May 16th, 2 to 3, 3:30 to 4:30, and 5 to 6. There's also an opportunity for any commissioner, and I'll send you the information about how to pop in to what's being called office hours. And that's going to be on May 12th from 2 to 6. But for the focus group, you need to choose one representative.
Does anyone have interest in doing so?
I would have interest if it was meetings in person. I hope this is the last virtual meeting I've ever do in my life. This is it. But I'm sorry, because of that, I cannot participate. I don't think I would be as effective as I could be in person. Thank you.
Thank you for Commissioner Maggio. Commissioner Kirpies.
I would encourage or recommend, if they'll accept it, either Vice Chair Copeland or Commissioner Ayers. If either one of them, I think they would represent the commission well, and they're both very level-headed and, live in the community and represent the community well. And that's, I would suggest one of them.
I'd be happy to do it. I attend the public safety meetings and neighborhood watch meetings anyway. I would be happy to do it, but if someone else, would really like to do it, I certainly would not mind. I would be happy to step aside, but certainly I would be honored to do it if not.
Commissioners, any comments? Commissioner Topshin?
Just I don't know if it's a comment or a question to Jonathan. Before I attended some other kind of this virtual presentations, or I don't know what you call them, but there wasn't a lot of engagement or interaction. It's basically, it was through Zoom, but the participants couldn't, make any obviously comments, or you didn't see any participants' names. It was just like, it was kind of pretty boring. There was like two people are presenting and talking, and there was no really, you didn't see how many people were in the room, or you couldn't see other people questions or comments. I think that kind of discourages from really attending and participating in this type of events. Forums. The format has to change. I mean, you have to be. It has to be a little bit more open for the community to be able to really engage into a discussion, see how many people are there, or see who is asking what type of questions. We just don't want to sit there and listen for 30, 40 minutes somebody's presentation. That's pretty boring. So I just want to.
Well, I'm not the one bringing this. I'm the messenger. So I don't know the details. Other than that, it sounds like it'll be relatively intimate, actually, because they're just asking for one representative from every commission, advisory board, and the social justice task force, and have 6 focus groups set up. So I don't anticipate that this is going to be a large group with people just presenting to the representatives. I think the purpose behind it is to get input. So whoever winds up doing it, if I'm wrong, I apologize. But I think it sounds like it's not just somebody talking at you.
Commissioner Ayers?
I agree that Vice Chair Copeland would be an excellent choice for this focus group. And if we need a motion, I move that Vice Chair Copeland represent our commission on this focus group.
Second.
All in favor? I think we can do it informally.
Aye.
Aye.
Okay, Vice Chair Copeland, do you accept?
Yes, I do. Thank you.
Wonderful. We appreciate it. Thank you for volunteering.
No, thank you for your confidence. I did have one question for Manager Holla while we've got you. I noticed on the next city council agenda, as far as the AB 361, item 2D is mentions allowing continued use of teleconference for commission and advisory board meetings. Is that something that, are we definitely going to be meeting in person, or is that something that might change between now and May 12th?
It could change if there's some sort of health and safety consideration that we're directed to comply with, but that's a separate, the item with council is a separate issue. I think that relates to, the state's authorization for these types of meetings, as opposed to
So as of
whether
right now,
we can do it or not.
okay.
As of right now, we're going to be in council chambers on May 12th.
Okay, wonderful. Thank you so much. Appreciate it.
Thank you.
Commissioner Maggio.
Yes, while we have Jonathan here, you did mention earlier that you want to agendize topics that we might want to discuss for a study session. But as I reminded you and talked to you before, that I had hoped this would be a mini and not a full study session, because a full study session includes many, many topics. And so a mini would really basically focus really on one. And the suggestion, of course, I'm going to make right now are rent increases, which I think we need to really hurry on learning more about. So I just kind of wanted to clarify what I meant by a mini versus a full study session. Thank you.
Okay. So I'm clear. So I don't agendize anything the commission doesn't want. When you say you're interested, well, just to give a little context, if you're talking about the rent increase freeze being lifted, is that what you want to discuss?
I'm talking about owners that come to us with capital improvements and want to increase rents based on whatever method we have decided to adhere to.
Okay, that I intended on bringing before the commission with the item that I'd been asked to bring back in August when I had brought the presentation on the pass-through increase regulation for security improvements. There had been some interest in revisiting that particular regulation, and in light of our last meeting and the appeal that was heard there and issues related to the rent increase process, my intent was to bring those together to discuss increases in general, which is what it sounds like you actually want us to do. So that will be agendized for sure. If that's what you're looking for, that'll come back.
And it seems to me that if that is the case, and those will be the topics, then we will probably be doing that in person as well, I think. Is that correct?
Hopefully.
I motion for
That's the
those.
plan.
I motion for those to be on Zoom for Commissioner Maggio. Only for you. We'll be in person and you can stay home.
All right. Well, thank you very much, Jonathan, for your message and input. But I think those are all important topics. Every topic is important, but sometimes I think we really need to zoom in on some of the things that haven't come before us very often. Thank you.
Okay, thank you.
All right. Anything else for Mr. Holub? Or anything else from Mr. Holub?
That's all I have. Thank you.
All right. Wonderful. Thank you for your time. Moving on. Mr. Secretary, do we have any public comment that has arrived?
No public comment at this time.
Okay, great. Moving right along to number 13, items from commissioners. Anything you thought of? Yes, Commissioner Kirpies.
Of course, because I'm going to be gone at the May 26th meeting. So I just want to remind everybody I will be gone at the May 26th meeting. And also I wanted to thank staff or thank council, whoever it is that kind of changed the direction and are going to continue to allow a hybrid type meeting moving forward. I think the last we had heard that they would not be hybrid. And so hearing that it will be some sort of hybrid meeting, allowing people to either call in or the full extreme of Zooming in is great, I think. And I hope that we can continue to do that. And then I just wanted to thank staff for their work tonight on tonight's staff report. I feel sorry for the tenant landlord who probably walked away with more questions than what they had when they came in. I know I did. And then also in regards to, since I will not be here on the May 26th meeting to talk about, I wanted to mention for when we do the study session, whether it be that study session or a future one, I would like to take a deeper dive on the deed restricted affordable housing limits on income. I know that I was surprised when we learned that after a few years, even though somebody's income could increase over the years, that they would still be able to stay in the designated affordable unit. And I don't want to, ever force somebody out of their home, but I also think that there needs to be a balance with these deed restricted affordable units. So hopefully it may not be in our direct purview, but I would like to learn more about it so that we can maybe influence, if we choose to, we can influence those who do make those decisions if necessary. And that's it. That's all I have. Thank you, everyone.
Thank you very much. Fellow commissioners, anything else to add? Okie dokie, I do not see anything. We're going to move to adjournment. This meeting is adjourned to the next regularly scheduled meeting of the Rent Stabilization Commission, which will be held on Thursday, May 12th. And for the first time in a long time, it will not be via teleconference. It will be in West Hollywood Park Public Meeting Room, Council Chambers. But as stated, the public can watch online and join via Zoom if they want to. But we will be there in person. Commissioner Maggio will be bringing treats for everyone. Thank you, everyone, and we'll see you then.
Okay,
Night,
good
all.
night,
Good night,
everyone.
everyone.
Bye. Thank you.
Take care. Thank you. Good night.